Wally. It's important to me to speak about the insurance market because there have been drastic changes to the industry and everybody's been affected. The state of the market is pertinent to the consulting engineer and has a direct impact on their risk management and their insurance profile. Like most specialist insurances, professional indemnity is sometimes administrative, time-consuming, and costly. It is very often attended to at the last minute, but I would urge you not to see this as a grudge purchase. It is most certainly one of the most important insurance covers to have. So forgive me for starting with some basics, but I thought it might be appropriate to touch on why you would need professional indemnity in the first place. It never is as easy as it seems, but if you give advice, design, supervise, or write reports, essentially, if you provide or charge a fee for a professional service, you need professional indemnity cover. And you simply need to ask yourself, what could go wrong? The insuring clause on a PI policy is very specific and is negligence-based. Only if an allegation of negligence is made by a third party will the policy be triggered. It relates to the total amount which the insured entity is legally obliged to pay in accordance with the law of any country, but not in respect of any judgment, award, payment, or settlement made within countries operating under the laws of North America. Some insurers also exclude Australia. The limit of indemnity is based on account of any claim, so this amount must be carefully considered before selecting an option. A very nice feature is that the deductible, or what some may refer to as an excess, is only payable when an award for damages is made against the insured. The policy will provide defense, though, in the interim. This policy would provide cover for a third-party claim against a firm in the event that the third party has suffered a financial loss as a result of the professional service you have provided. Unlike a reasonable person test, in a court of law, a court would look to what the reasonable professional would have done in determining liability. You don't need to be guilty of an error, so to say. You just need to be accused of some sort of negligence. The policy, if triggered, would cover damages, legal costs, expert expenses, and VAT. Insurers have indicated that a day in the High Court ranges from 150,000 Rand upwards. There are a host of ways in which a professional can be held liable by virtue of the office that they hold. Professional liability is of utmost importance. This is the duty owed to the community. For example, a bridge collapse or pro bono work, which is incredibly onerous. What is important here is that regardless of whether a fee is being charged, there is still liability. Then in terms of statutory liability, this is when a professional can be held liable in terms of statute, legislation, acts, or a piece of law. Take, for example, the Occupational Health and Safety Act that dictates what is required from a designer. Generally speaking, when the law is silent on who should be held liable, the professional is in fact held liable. Non-compliance with legislation generally attracts fines and penalties, which are not insurable under this policy. Another form of liability is in terms of the law of delict or tort. All 5 elements of delict must be proven. This is discussed because even if there is no agreement in place, there is still liability. Then contractual liability. Our guidance here is that you should never take on more responsibility or liability than you are ordinarily liable for. Don't agree to things that will prejudice the PI policy. There is a danger in signing documents you have not read. This will not be accepted as a defense, and there is no way out of this. You will be held liable. Over the past at least 13 years, insurance has been in what was deemed to be a soft market. The risk was attractive to insurers, and as a result, there were several insurers wanting to accept the risk. This drove down the premiums, and different covers not usually seen on a PI policy were provided for free. But with PI claims being long-tailed, These claims are now coming home to roost, and insurers have advised that the premiums previously charged are no longer sustainable for the risk that they hold. Unless this trend changes, some insurers have commented that in a few years from now, we may struggle to place PI within our existing South African markets. Personally, I don't believe we will find ourselves in that position, but the thought of that alone is concerning. The insurance arena has now officially entered a hard market. This affects factors such as increased prices, stricter underwriting criteria, reduced capacity, increased deductibles, and more selective risks. This means that all clients across all professions are experiencing increases to their premiums, irrespective of whether they have claimed against their policy or not. And even more considerable rate increases have been experienced by professionals with an adverse loss ratio. Higher minimum deductibles have been imposed on certain risks, and capacity within the insurance industry is challenging. In the past, where one insurer was able to provide 100% capacity on a risk valued at, say, 500 million, as part of their own risk management, on any high risk in terms of business activities or limits of indemnity purchased, insurers will now only offer a maximum of 60%. This means a high risk previously insured by one insurer for 100% capacity must now be co-insured with another insurer, which brings a host of complications. For starters, whoever the lead insurer is gets to dictate the policy wording and the pricing, and the supporting insurer has to accept the lead insurer's pricing and policy wording. If you recall me saying previously that that in the soft market, covers not usually provided for under a normal PI policy were thrown in for free, this now becomes challenging as one insurer may not agree with what another insurer's policy wording states. While I mentioned the price increase to premiums, the biggest challenge is actually capacity in the market. In addition, COVID-19 exclusion or the infectious diseases exclusion is now applicable on all professional indemnity policies, irrespective of profession. Insurers have provided us with common claims trends for the past 3 years. The majority of claims relate to defective design, which later led to either collapses or other types of problems that required remedial work. There have been inquiries made by our clients relating to cost cutting or discounting of fees when bidding for tenders, asking whether there would be a negative effect on their PI policies. Insurers will respond and assist on a claim, provided that the quality of work is still maintained and that all the relevant specialists are still appointed. Basically, no corners can be cut. Such discounting shouldn't affect insurance if the quality standards are present. Insurers cannot dictate what the client charges in any event. A huge concern, however, for insurers is that member firms are not reporting their incidents or the possible matters timeously. Engineers would attend site meetings, attend to remedial works, and they would still not notify potential circumstances. Only once a claim emanates, then do they deem it necessary to report. This is automatically seen by insurers as a late notification, and insurers have every right to reject such matters. Of all the professions we deal with at Aon, we find engineers in particular do not notify their claims in time. Post the construction boom, claims frequency and severity have increased significantly. The purpose of this slide is to indicate that it is not immediately evident to demonstrate which discipline is responsible for a claim as soon as it is reported to insurers. Professional indemnity claims take approximately 5 to 7 years to finalize. A lot is involved. Assessors are appointed to determine where the liability lies, which is why you can see that based on 78 CESA claims reported or notified in 2019, 73% of these claims are still undetermined. The claims with the largest impact, however, arise out of civil and structural engineering. Due to the increased number of claims, legal defense costs incurred by insurers have increased significantly, especially arbitration costs. Current unresolved large claims under project-specific PR policies, combined with an increase in PR claims across the various professions, together with the CESA portfolio claims, are bound to influence the local markets adversely. Between 2014 and 2020, the CESA portfolio with Aon moved between two insurers, namely SHA, underwritten by Santam, and R2, underwritten by Hollard. Both have their own claims reports. Between 2014 and 2017, SHA reported what we refer to as intimated claims, valued at over 2.7 billion rand. When a notification is made, insurers look at the amount of the potential claim and the limits of indemnity purchased. And this is how they arrive at this very high figure. But it's obviously cause for concern. Remember, due to the complexity of the PR claims, they generally require investigation, which also add to the insurer's costs. Even if a claim is not settled, insurers still spend money on investigating and defending, which involves specialized assessors, attorneys, and other experts as required. Between 2014 and 2020, however, after investigation, a more accurate figure emerges as the investigations progress, and this number reduced down to 142.7 million rand. Of the 142.7 million, 85 million relates to open claims, with 57.1 million being claims that have been finalized. To put things into perspective, claims are currently 142.7 million. However, premium collected between 2014 and 2019 was only just over 118 million. Like any business, loss ratios are very important, and premium needs to exceed claims in order for a book of business to be profitable. Claims aside, premium is generally calculated based on your fees earned from the previous financial year. The rates charged depend on the various disciplines you are involved in, and PR policies are annual policies which do not renew automatically, and they must be reviewed and renewed each year. We encourage policies that are written on an each and every claim basis as opposed to an annual aggregate limit. We're able to provide quotations for single project policies, but these are very expensive and very few insurers provide this cover anymore. As mentioned previously, a nice feature on the Aon CESA engineers policy is that excesses apply to damages only, so you will not be required to pay the excess for legal defense costs. Approximately 90% of our business within professional risks falls within a binder, where we are able to negotiate the terms and conditions with insurers for the clients who fit within the binder mandate. The balance of our business is placed into the open market. We have a binder for each profession, whereby a market exercise is conducted in advance for all binder clients, instead of having to repeat the exercise for every individual client at their renewal. We are able, therefore, to obtain the best possible extensions and the best possible quotes available in the market. Lastly, we have an incredibly comprehensive wording, with extensive extensions, carving back restrictions on traditional PR cover. We're always proud to share some facts with you. Professional indemnity is a specialist line of insurance, and insurers trust our capabilities and our expertise. We sit on various industry-specific committees, including CESA, helping us understand your business. One of our key highlights is our legal risk management services offering, which many of you will be familiar with. The requirement for better risk management is essential, now more so than ever before. As mentioned previously, insurers have taken a stance on being more selective when it comes to what risks they accept. Risk management is of paramount importance. We pride ourselves in providing service excellence. We understand and acknowledge the importance of focused risk management. The built environment has its own unique challenges that we are committed to understanding and assisting and advising on where we can. We have a keen focus on education, which is always a highlight for us at Aon. For example, our involvement in the BCE training programs. The practice notes journey provided us with an opportunity to place a magnifying glass on topics such as liability for negligence, the importance of limitation of liability, risk reduction and claims exposure, and liability aspects of the construction regulations topics, which we primarily believe have a direct impact on the consulting engineer today. Your feedback to us is always appreciated. We want to listen, and we want you to know that you are at the heart of everything we do. Thank you very much for listening to me speak about something that I personally am very, very passionate about. Please feel free to contact me directly or to speak to your Aon client manager or our legal risk team about anything we may be able to assist you with. Thanks, Wally. Over to you.
Thank you, Clarissa, for giving us a great overview of the industry and the trends and so forth, and for presenting so ably on a topic that is of great interest to our members. So thank you very much.